Thinking about bringing your spouse or parent to the U.S.? It's a journey filled with hope, but the paperwork can feel overwhelming. Don't worry, I'm here to break down the process of sponsoring a loved one for a green card step by step. It all starts with Form I-130, the petition for alien relative. This is the cornerstone of your application. You, the U.S. citizen or lawful permanent resident, are the petitioner. Your spouse or parent is the beneficiary. The goal of this form is simple: to prove to the U.S. Citizenship and Immigration Services, or USCIS, that your relationship is real. So, what documents do you need to gather? First, proof of your status. If you're a U.S. citizen, that means your birth certificate, passport, or naturalization certificate. If you're a green card holder, you'll need a copy of your green card. Next, you have to prove your relationship. For a spouse, this is crucial. You'll need your marriage certificate, of course, but you need more than that to show it's a bona fide marriage. Think of it as painting a picture of your life together. Collect photos from your wedding, vacations, and holidays. Gather joint documents like bank statements, lease agreements, or utility bills in both your names. Affidavits from friends and family who can vouch for your relationship are also powerful. For a parent, it's a bit more straightforward. You'll need your birth certificate showing your parent's name. If your name has changed, you'll need the legal documents for that too. Once you've compiled all your documents and filled out the I-130, you'll file it with USCIS. After filing, you'll receive a receipt notice. This is important. It has your case number. Now let's talk about timelines, because this is what everyone wants to know. It varies a lot. For spouses of U.S. citizens, the process is generally faster because they are considered immediate relatives, and there's no visa limit. It could take anywhere from 10 to 18 months, sometimes longer. For spouses of green card holders and parents of U.S. citizens, the wait times can fluctuate based on USCIS backlogs. The best way to check current processing times is to go directly to the USCIS website. After the I-130 is approved, what happens next depends on whether your relative is in the U.S. or abroad. If they're in the U.S., they may be able to apply for adjustment of status using Form I-485 to get their green card without leaving the country. If they're abroad, the case moves to the National Visa Center, or NVC. The NVC will process the case and schedule an interview at a U.S. embassy or consulate in their home country. Now let's discuss some common red flags that can cause delays or even denials from USCIS. A big one for spousal petitions is a lack of evidence of a shared life. If you don't have joint bank accounts or a shared lease, be prepared to explain why and provide other strong evidence. Large age gaps, different cultural backgrounds, or a history of previous immigration petitions can also raise questions. The key is to be honest and provide as much documentation as possible to support your case. Another red flag is inconsistencies. Make sure all the information across all your forms and documents is accurate and matches up perfectly. Double-check names, dates, and addresses. The immigration journey requires patience and attention to detail. This information is for educational purposes and isn't legal advice. Because every case is unique, it's always a good idea to consult with an experienced immigration attorney. They can help you navigate the complexities and ensure your application is as strong as it can be. Thanks for watching. I hope this breakdown was helpful. If you found value in this video, please give it a thumbs up and subscribe for more guides on navigating the U.S. immigration system. See you next time.